Hi everyone, I'm attorney Aiden Durham with 180 Law Co. in Colorado, and you're watching a very special episode of All Up in Your Business. So on this episode of All Up in Your Business, we're going to be joined by my good friend and colleague, Tamara Pester, who is a great and very experienced trademark and intellectual property attorney in the Denver, Colorado area. Tamara and I are going to be talking about trademark oppositions and cancellations and the TTAB, or Trademark and Trial Appeal Board proceedings. So if you've ever wondered, what do I do if someone says that I'm stealing or infringing on their trademark, or if someone tries to prevent me from registering a trademark, or what do I do if I find somebody who's trying to register a trademark that's similar to mine or tries to use a trademark that's similar to mine? We're going to be answering all those questions and talking about a really exciting course that Tamara has developed to help all of you non-lawyers learn trademarks. But before we get into it, of course, don't forget to like, subscribe, and share, and check the description for links to additional information and resources. All right, now let's get into my conversation with Tamara Pester. All right. Hi, everyone. Welcome my special guest for this episode, Tamara Pester. Tamara, like I said, is a very experienced trademark and intellectual property attorney, and I'm excited to have her join us for this episode to talk to us about cancellations and oppositions and basically what to do if someone tries to steal your trademark or thinks that you've stolen theirs or other issues come up. Welcome, Tamara.
Thank you. I'm excited to be here.
Yeah. So just give a brief introduction of yourself. Tell us a little bit about you.
Yeah, I've been practicing law for more than 20 years. I've had a variety of different legal experiences. I started at a really big firm. There were like 800 people, and all I would do were trademark applications day in and day out. After a couple years of that, I went in-house to a software company where I got a lot wider exposure to different areas of law, like employment law, business contracts, software licensing. And I've pretty much continued with those couple areas: business contracts and software licensing and trademark prosecution and defense for most of my career. I did work for another company after my company got acquired. And then I started my own practice about 15 years ago. So as you know, Aiden, I know you and I have worked together on a couple trademark trial appeal board opposition proceedings. That's probably about a quarter of my practice, I would say. And the rest of the time, I'm helping people register their trademarks. I'm helping them write cease and desist letters, or I should say I'm writing cease and desist letters on their behalf. And I help them negotiate various types of business contracts, vendor agreements, customer agreements, stuff like that.
And you've recently developed a course to help people learn trademarks. Tell us a little bit about that.
Thank you for reminding me. So I also recently started a class called Learn Trademarks. It's learntrademarks.com to help people who might not otherwise be able to afford a full-fledged attorney, holding their hand through the whole application registration process. It's 4 modules. It's about an hour and a half in length. So in the various modules, they're designed to give people an overview of intellectual property. That's the first module, kind of the difference between trademarks, copyrights, trade secrets, and patents. In the second module, we take a deep dive into what a trademark is, what it can and cannot do. In the third module, we have common myths and misperceptions about trademarks, which I'm sure you and I will talk about during this session. And then the last module, I think you also have a class similar. In the last module, we're actually going through the trademark application, the U.S. Patent and Trademark Office application for registration of a new trademark. And I'm kind of interactively discussing the different steps and what you should fill in and what you should not fill in, and, the little trick to not include your personal home address for public view, stuff like that.
Perfect. Yeah. And I think it's great because my course, Brandish, focuses just on the application process itself. But a big part of that is understanding what a trademark is and what we're even dealing with, which is why I think your course is great, because it really gives that overview of what is this thing that we're even dealing with to begin with.
If people have been watching your videos all along, then they probably don't need to take the class, because I think that if they've been, consistently following like all of your presentations, and you do a great job on social media, they probably could learn a lot from that. This is designed more for people who just want to kind of get a quick and dirty overview of intellectual property, make sure they're not wasting their money on the trademark application fee and doing it the right way and applying for something that's actually registrable.
Perfect. Yeah, we'll talk a little bit about it again at the end of this video and give people info on how to sign up and all of that. Awesome. So let's see, if you guys have been watching my videos, I'm sure you've heard me talk about trademarks and the application process. And part of the process of getting a trademark registered is this opposition period, where after the examining attorney with the USPTO, they vet your application, do all their checks and balances, and then it gets published for 30 days in the TMOG, Trademark Official Gazette. And this is an opportunity for kind of the general public to oppose the registration if they think it might somehow step on their own trademark in some way. And the way that Tamara and I really got to have some fun working together was I was filing an application and someone filed an opposition against the trademark. And this was my first time dealing with an opposition. So I had pretty much no idea what to do. So of course I reached out to Tamara, and that was to get some additional help and have her, kind of guide me through that process. Tell us if from the applicant's point of view, what's the opposition proceeding like? What should we expect to encounter if someone files an opposition against our application?
Well, hopefully if you've done your searching correctly and there's no one else out there with a similar name or design mark, or, in the weird trademarks like smell, color, or sound, then there won't be any oppositions. But, maybe your client is more open to risk and they know that there is a risk that someone would oppose them, or that there's something else out there that might conflict, and they've decided to go ahead and apply anyway. And then voila, the opposition period comes, and lo and behold, someone filed an opposition against them. Well, first they'll get a notification from the Trademark Trial and Appeal Board that an opposition has been filed. And if there's an attorney on record, that attorney will get the notification. It'll be directed to the attorney who's on record for the file. If they've applied on their own, they will receive it at whatever correspondence address they have indicated. They will then have 30 days to respond. Oh, let's back up for a second, though. It's kind of unusual for someone to just go ahead and file an opposition. Parties do have these requests for extension of time to oppose. You can file a 30-day extension for time to oppose at no cost. So if someone's been monitoring their trademarks and they see that someone else has applied and the opposition period has opened up, usually what they'll do, unless they're super aggressive, which does happen sometimes, but usually what they'll do is just file the extension and then contact the applicant and be like, hey, we saw that you applied for this mark. You might not be aware, but we actually have rights in a very similar mark and you need to stop using it. Otherwise, we will file for an opposition. If the people don't respond, or if they're still in communications about that and the application hasn't been withdrawn yet, then the opposing party can file a second and third request for extension of time to oppose. And by the way, these are like automatically granted. It's not like there's someone at the Trademark Trial and Appeal Board examining it and thinking, oh, I don't know, should I let them extend or not? It's pretty much always automatic as long as you're filling out checking the right boxes, on the form. So you basically have up to, I guess it's about 120 days total. It's 120 or 150. You have a while, over 100 days, to continue filing these extensions. And then finally, at the end, you either need to file an opposition or you lose your chance to do that. And then you'll have to wait until the trademark gets registered and then either file a cancellation proceeding or sue them in federal court.
Mm-hmm. Okay.
So back to your original question. when someone gets an opposition, they're pretty freaked out. If they're not represented by an attorney, that's when they'll get the call, as you know. And then you need to respond pretty quickly. And the initial response can just basically be like, yes, no, yes, no, yes, no, unless you want to file a counterclaim. You need to do a little bit more research, but it is important to file a response in a timely manner. Otherwise, they get default judgment.
Right. Okay. So it sounds like we get some heads up in a lot of cases if they file these extension requests. At least we know potentially an opposition will be coming, and we have an opportunity to maybe resolve it or avoid that from happening one way or the other.
Yeah, exactly. And these extension requests can also give you a pretty good indication of what resources they're willing to devote to it. If it's a letter on a law firm letterhead, then generally they're more serious, especially if it's a bigger firm. I mean, not to discount people like you and I who are smaller firms, but if it's a law firm in general, that means they've engaged an attorney to write this letter and give the other party a heads up. If it's just someone doing it on their own, then it could be that either they don't have the funds to engage an attorney, or they just want to do something a little bit simpler and more, approach it from a more like alternative dispute resolution standpoint, where they're not necessarily going to go ahead with the full opposition, but they do want to get your attention and communicate with you and see if they can work something out about concurrent use of the similar marks, or just get you to kind of back down without a fight.
And so the TTAB, the Trademark Trial and Appeal Board, if you're not familiar, it might sound like this is, we're going to trial. This is a serious legal thing that we're getting into, but it's not exactly that. We're not appearing in front of a judge. There's no jury that we have to talk to. What's the TTAB process look like?
Yeah, so the Trademark Trial and Appeal Board is definitely a unique process because you have these interlocutory attorneys who are like judges. You have paralegals. You have a lot of the things that look like a lawsuit, but it's really not. Even if you ultimately go to trial, which is pretty unusual, usually they settle at some point during discovery. The trial is like a conference call. And, you get the opportunity to write briefs and research and write motions like you would in a normal court case. But it is generally a lot less expensive because you're only focusing on the issue of whether or not the trademarks are likely to cause confusion. That's the most frequent opposition proceeding, is an opposition based on confusing similarity. Sometimes you'll do a cancellation proceeding, and the cancellation proceedings can vary a little more. It's not only the confusing similarity, but sometimes it could be cancellation based on fraud or non-use. And as you know, under the Trademark Modernization Act, towards the end of the year, I think they're finally going to give us the opportunity to request for expungement of a mark without going through the whole cancellation proceeding. So I'm looking forward to that, because I feel like there are a lot of trademarks on the register where people aren't really using it, or at least aren't using it for this long list of goods and services that they have registered it for.
Right. Absolutely. Yeah. I encounter that pretty frequently, where, we do the search before we submit the application, and maybe there's a trademark that comes up that would be confusingly similar, but digging into it, it looks like this business has been dissolved for 4 years. There's no record of them on the internet anymore.
Exactly.
And so hopefully giving us an easier way to deal with those situations through the Modernization Act.
Yeah. So you asked more about the process. So other than generally just having like a lot of the same steps, you also have generally shorter timeframes. Like discovery starts pretty quickly into the process and is limited in time period unless the parties agree otherwise. I mean, it's all like the parties can always agree. There's also this, I haven't had anyone take me up on it yet, but there have been a few instances where I thought the accelerated case resolution would be a great way to speed some things through the process. If you just focus on, I had one recently where a large energy drink company filed an opposition against my client's mark, who is using kind of I don't even think it's arguably similar, but they both have sort of claw marks. And this energy drink company filed an opposition. My client had 2 applications pending, both of which use various words together with a claw mark design. They operate an online marketplace selling for allowing people to buy and sell empty containers in mass quantities. We're pretty sure that no one would accidentally buy a energy drink for $1.25 when they meant to buy like a pallet of shampoo bottles. And I tried to get the accelerated case resolution on that matter, just so that we could focus on whether there was any likelihood of confusion or actual confusion. But of course, they declined, and we had to go through the normal steps. And actually, in that matter, sadly, my client just got outspent. The energy drink company was represented by a huge firm. They had like 4 lawyers on the case. I'm sure they were charging $800 an hour each. We just got to like the initial stages of discovery, you know, where you're exchanging information that's relevant to the case. They submitted their request for interrogatories. We responded. We submitted our request for interrogatories. They responded. In each of our responses, there are a few objections, because you can object to questions that are irrelevant or repetitive or any number of other things. I tried to be pretty conservative about the objections. Like, we really were just asking for clarification. However, the other company had like basically objections to every single answer that we submitted, and then requests for additional information. And then right after that, they did a request for deposition of my client. My client was like, you know what, I don't care about this enough. Like, it's a brand that we haven't even really gotten going on, and I just can't afford to spend thousands and thousands of dollars on end. So sadly, they gave up the applications.
Bummer. Yeah. That's I hear a pretty not totally uncommon thing when you're dealing with larger companies that just have a lot of money to outspend you on.
Yeah, it was unfortunate.
Yeah. Well, speaking of the discovery and the exchange of information, a interesting experience that Tamara and I had working together on that case where I had her helping me with an opposition. So my client had filed an application. Somebody wanted to oppose it, and the marks were very similar, practically identical. And so in discovery, it kind of came down to who dates of first use, who used the trademark first in which jurisdictions and which geographic areas. And that was kind of going to be the crux of this dispute, was first use of the mark. And then some interesting things followed. Do you want to tell people about that?
Oh my gosh. Yeah, I will never forget that, Aiden, because this has never it never happened to me before, and it has not happened since. Although I did have a client kind of question the other party's disclosure of the date of first use recently also. But yeah, I remember that case very well. So it was 2 companies. Actually, the ladies, I think, knew each other in the same community. They both had schools to teach students about one particular type of aesthetic. They both had rather descriptive marks, which, you know, I'm sure you counseled them that they should have just chosen a better mark to begin with. But unfortunately, our client and the other side both had marks that were pretty descriptive of this, you know, service that they're teaching people how to do properly. And our client, by the way, was like super skeptical from the beginning, which happens sometimes. I mean, some people are skeptical of legal processes in general, but she was like pretty skeptical, like one of the more skeptical clients I've ever had, where pretty much anything that came in from the other side, she'd be like, "Are you sure that's right?" And then when it did finally come down to who was using it first, I remember the other side sent, I don't remember what it was exactly, but they sent some document. I think maybe it was an advertisement of the first time that they said that they were offering classes. They sent an advertisement. It didn't have any dates on it, but the attorney indicated that it was from a particular date. We asked them for more proof of that particular date. Oh, I know, it was an invoice.
Yeah.
That's what it was.
That's right.
It was an invoice for maybe like the room that the building they were renting, or the room they were renting, or I don't know, something related to their first class that they held. And it was an invoice. We asked their attorney opposing counsel for more proof of that date. And he sent back a document, like an email chain that included an email from the his client to their graphic designer saying, hey, can you guys edit this invoice and make it look like I was actually using it a year earlier?
Mm-hmm.
And I remember I called you and I was like, oh my God, did you see what just came across? And we were both like astounded because clearly this person was committing fraud. And I don't remember whether we had a phone call with the opposing counsel or whether we just like sent his email back to him and we're like, do you realize what's in this attachment? Your client is committing fraud. And then he had like a noisy withdrawal where not only did he withdraw from representing them, I think he also filed something with the Trademark Trial and Appeal Board saying that he was withdrawing because of fraud.
Uh-huh.
And then, of course, after that, the other party stopped fighting it and just let our client have the trademark. But oh my gosh, that was crazy.
Right. Yeah. You talk to people and they're skeptical about, is someone fudging evidence or fudging documents? And rarely is there actually some substance behind that. But in this instance, that was exactly what it was. They were just faking the dates. And we got pretty clear proof of that. And I mean, in the end, it ended up working out great for our client, and she I think was very vindicated in her feelings from the beginning too. But that was a pretty crazy experience. And I think that the big key takeaway for people watching is be truthful on your trademark applications. Number one, be truthful with your attorney and be truthful in all regards in any kind of legal proceeding that you're entering into, because if you don't, it's usually going to come out one way or another. And that's
careful with those graphic designers.
Yeah. Right. Yeah. So let's say we are a trademark owner and we find someone that we think is infringing or using a trademark that's the same as ours or something similar. What options do we have as far as, or let's say they even have a registered trademark themselves. What options do we have for enforcing our rights, whether it's canceling their trademark or suing for infringement or something like that?
That's a good question. So, and as you know, it all depends on the date of first use. So assuming that we were using the mark first, there's a couple options. I usually start with a cease and desist letter and just give them the opportunity to resolve it informally. Not everyone responds to those. So then, you have the opportunity to either file a cancellation proceeding and get their registration canceled based on your prior rights, or you can sue them in federal court. And people get confused sometimes about what the true effect of a Trademark Trial and Appeal Board proceeding is. And it's a little bit funky because Trademark Trial and Appeal Board proceedings really are like nothing else. And people can end up kind of spinning their wheels a little bit. So even if you have a successful cancellation or opposition proceeding, it only relates to the right to have that trademark on the U.S. Patent and Trademark Office register. It doesn't necessarily affect use in real life. However, due to case law, Trademark Trial and Appeal Board proceedings do have a persuasive effect on later filings in federal court. Does that make sense?
Yeah.
I know it makes sense to you, but let's just make sure it makes sense to the audience. Right. So what we're saying is if you file or if you're defending a Trademark Trial and Appeal Board proceeding, it doesn't mean that if you win that the other party is going to stop using their trademark, or if you lose that you need to stop using your trademark. That's why I mentioned that client that was against the energy company. They were just like, who cares about that slip of paper? Maybe we'll keep using it anyway. And by the way, the energy company hasn't actually filed against them in federal court. So my client did decide just to rebrand altogether after a little bit because they didn't think it was worth the risk that the energy company could someday file against them. But that's what's a little bit frustrating to people. And what a lot of people don't fully understand is that winning or losing a Trademark Trial and Appeal Board proceeding really doesn't necessarily affect your use in real life. It only affects your rights to get that registration.
Right, exactly. And that goes for the registration altogether too. I explain to a lot of clients that, even if we don't get the trademark registered in the end, that doesn't mean that the USPTO isn't telling you can't use this trademark for your business. They're just telling you we can't register it. And same thing with TTAB. proceedings, it's you may not have the actual trademark registration, but you still are able to continue using it in your business or for whatever purposes, unless some other, legal proceeding comes up where you're actually ordered not to.
Yeah, exactly. That is one of the biggest trademark myths. And that's actually something I talk about in the module of the Learn Trademarks class, where I think it's module 3, where I talk about common myths and misperceptions. People sometimes think that they need to register a trademark before they can start using it. But as you know, people have common law rights in their trademarks in the geographic area where they've been using it, and beginning on the date of first use in connection with those particular goods and services. And these days, the geographic area is pretty frequently, if not worldwide, at least throughout the United States, due to the internet. So if you're selling goods or services and you have a sale across interstate commerce between 2 states or between the United States and another country, there you go. You've got federal rights.
Right, exactly. Is there one thing that you see happen often, or if you have one tip or suggestion for someone that is looking to get a trademark registration? What's the number one thing that you can tell someone to help with that?
That's a great question. I think that the number one tip is that I cannot emphasize enough the importance of doing a comprehensive search before you apply and making sure that your mark truly is clear for registration and use, because a lot of people think that if they just do a quick knockout search, if they look in the Patent and Trademark Office for that exact trademark, that it's available, they can go ahead and register, they won't have any issues. But as you know, Aiden, there could be a lot of other companies or individuals lurking out there who using the same or similar mark for the same or similar services that will only be revealed through a comprehensive search through additional databases like Secretary of State records or state trademark registrations or Dun & Bradstreet records or even the internet or social media. So before people apply, well, first of all, of course, they should take my class.
Sure.
But if they don't either take my class or work with one of us or another reputable trademark attorney, they should at least do their own very thorough search before they even think about applying.
Absolutely. Yeah. And that's something people don't often realize. It's just because your exact trademark doesn't show up doesn't mean that you're in the clear and you're going to be good to go to get that trademark registered. Yeah. The very first, my very first trademark application, I was still learning all this stuff. I was brand new to it. Luckily, this was a friend that I was doing it for. So I did a direct hit search, didn't see anything come up, and I was like, all right, I think we should be good. It turns out it wasn't. And the issue was my trademark included the word pooch in it. And there was another one which was the same, except for pooch, it was the word dog. And pooch and dog, they mean the same thing, even though they're very different words. But that was close enough that the USPTO thought they were confusingly similar, and we ended up having to let the trademark application go.
Oh, that's too bad. Live and learn.
Right? Exactly.
But then your friend wasted the application fee as well as the time spent waiting for the application to get to assigned to an examining attorney, which when you first started out probably was still like 2 to 3 months. These days, I mean, is it taking forever? It's taking like 5 or 6 months for my applications to get assigned.
Yeah, it's crazy. I have a few that I've filed at the end of last year that are still not assigned.
Yeah, same. Yeah. So if someone doesn't do their search properly, then not only are they throwing away their $250 or $350 filing fee, depending on whether they do T's or T's plus, they're also just like sitting on the edge of their seat for more than 6 months, waiting to see what happens. And, hopefully not investing too much in branding or marketing by then without knowing that their mark truly is registrable and not conflicting with something else.
Right. Exactly. Well, thank you so much, Tamara. Tell people how they can find you, if they want more help, or how they can get more info about Learn Trademarks.
Yeah. So Learn Trademarks, we're on learntrademarks.com. On Instagram, we're also at Learn Trademarks. I believe that you have a link to it.
Yep, I'll be linking. I'm going to link to all this in the description too.
Yeah, so you can follow Aiden's links, or go to the website, or reach out to me through Learn Trademarks or Tamara Pester Law, or just talk to Aiden if you have a TTAB matter, and maybe we can co-counsel again. I sure had fun those last couple times we did it, and I know our client was really happy that last one, especially.
Yeah. it ended up working out. So
yeah,
it was all good. Yeah, definitely.
yeah. Well, this was so much fun, Aiden. Thank you for having me.
Yeah, of course, of course.
I really feel like we could go on for like hours and hours, but people might get a little bored, and I tend to overwhelm people with all the information. So maybe we should parse it out.
I know, really. Well, we can save it for another episode, another video at least, and talk way more about it, I'm sure.
Yeah.
Great. That's all for this episode, folks. I hope you enjoyed my conversation with Tamara. I hope this learning something about the opposition, cancellation, proceedings was helpful and educational for you guys. Like we said, check the description for links to her Learn Trademarks course, or if you want to get in touch with Tamara, all of her info will be down in the description. Thank you all so much for watching. I'm Aiden Durham, and I'll see you next time.